Good morning, everyone. I hope that everyone had a good night's sleep last night, as we are going to have a very interesting session this morning. The fourth session will be held at 10. Now we are in this session, we will closely examine how to calculate damages, including enhanced damages. 이번 세션은 IP 분쟁의 매우 뜨거운 주제를 다루고 있기 때문에 굉장히 기대됩니다. 바로 손해배상액 산정 부분입니다. I'm delighted to present the session's moderator, Honorable Presiding Judge Tae Il-bak of Seoul Western District Court. Please join me in welcoming him. 박태일 부장판사님께서 좌장을 맡아주셨습니다. 큰 박수 부탁드립니다.
네, 안녕하십니까. 방금 소개받은
Good morning. I am Judge Park Tae-il.
어제 열띤 논의를 모두
We
마치고
had
둘째 날
a very
수고하셨습니다.
active discussion yesterday, and we are now opening day 2 of the conference. I hope today will also be as equally fruitful to all participants. The session is going to handle the theme of damages calculation and procedures for lawful protection of IP rights. The IIPCC conference discusses very specific and hotly debated issues in the IP field where we are shared with cases from various countries. As I was preparing for the conference, I once again was able to appreciate that fact. I would like to once again thank our panels from home and abroad for session 4. Now, without further ado, we will commence session 4. I would like to introduce the panels in the alphabetical order of their surnames. We have a lot to cover, so I will try my best to be concise. From the U.S., we have Judge Kathy B. Soon from U.S. Court for the Western District of Pennsylvania. She is with us here. We have Presiding Judge Tomonari Honda from Intellectual Property High Court of Japan. We will watch a recorded version of the presentation. We have Judge Hyung Jung from Incheon District Court with us here today. And we have High Court Judge Kwangnam Kim from Seoul High Court. From Germany, we have Judge Annalena Klein from the Regional Court of Munich 1. She's with us via Zoom. And we have Judge Jing Liu from Hainan Free Trade Port Intellectual Property Court, China, live with us on Zoom. Yes, we can see her. Thank you for being with us. And last but not least, we have on Zoom High Court Judge Richard Mead from High Court of England and Wales. Despite the blackout situation, he made it to the conference. Thank you very much. Yes, we can see that your lighting gives off a very good ambience. Now, these are all judges active in the IP field, and they all have their respective titles, but since the time is of the essence, we will just address them as judge. Before we dive in to the discussion, I would like to introduce the table of contents or the index, and each of those issues have more detailed questions. In fact, we have sent out written questionnaires, and we have received very enriching detailed responses, which are all in the reference book. We have the translated version also in the reference book. And we have the responses for additional questions to individual panelists. Thank you once again for the response. For the efficient proceeding of the conference, we will ask a number of questions at once, or we might have to skip some of the questions, so we ask for your understanding. We will start with the royalty-based damages calculation.
실시로 상당 금원을 손해배상액으로 산정하는 방법 및 이때
So,
고려되어야
in the
하는
patent
요소들이
infringement
무엇인지,
litigation
그리고
practices in your
각
country,
고려 요소의
may
증명
an
책임이
amount
누구에게
equivalent to a
있는지
royalty be
질문드립니다. 답변
calculated as a
시간은
loss? If so,
2분
how
씩
is the
부탁드리겠습니다.
calculated
먼저
and
독일의
what
프라임
factor should be
판사님께
considered
부탁드립니다.
and who bears the burden of proof for each factor?
프라임
And
판사님.
Judge Klein, would you go first?
Thank you so much. Good morning. In Germany, damages may be based on royalty. Damage calculation based on royalty is one of three methods that we use in Germany to calculate infringement damages in patent cases. The three methods are lost profit, infringer's profit, and royalty damages. Now, how are those royalty damages calculated? They shall be calculated based on the objective value of the patent usage. The objective value might be hard to determine at times. The relevant aspect is the royalty amount reasonable parties, contractual partners, would agree on when arranging a license contract. So the courts need to establish the appropriate common royalty. The circumstances of the individual case must all the time be taken into consideration. According to German case law, the infringer shall be neither better off than the licensee nor worse. This means that generally damages based on royalty shall not have punitive character. Now, who bears the burden of proof? Generally, a party bears the burden of proof if they rely on a debated fact, which is positive for their claim or their defense. Nevertheless, the infringed party in such a damage calculation case must only prove the amount of a royalty which would commonly be used in practice. Infringed parties do not need to prove that they would have lost profit, that the infringer has gained profit, or that they would have made a license contract. The courts may estimate the damages if the infringer provides enough fact to really estimate some sort of damage. The court may also, and will in many cases do so, consult an expert concerning the damages. Thank you.
네, 이어서 미국의 비슨 판사님, 미국
Next,
부탁드리겠습니다.
Judge Bisson.
Good morning, and thank you again for having me. With respect to damages in the United States, we have two measures of damages. One is lost profit, and the other is reasonable royalty. Reasonable royalty is the most common way of measuring damages in the United States, and I'll explain a little bit later on why that's the case. With respect to reasonable royalty, there are a few methods that are recognized by our courts. One is an established royalty. So if a plaintiff normally has a rate of royalty that it typically uses for licensing its product. The other is what's known as the Georgia-Pacific factors. And this is an unusual thing in the United States. It is based on a hypothetical negotiation between a willing patent holder and a willing licensee at the time that the infringement occurred. And so what would the negotiation be if those two entities had negotiated at the time that the infringement occurred? And we recognize that it's a fiction, but this is as close as we've come to determining what the parties would have decided if they had been negotiating in good faith between one another to come up with a royalty. I'll mention a few other things with respect to burdens of proof. In the United States, plaintiffs always bear the burden of proof in terms of demonstrating damages. The defendant does not bear the burden of proof as to damages. It may bear burdens as to the defenses in the case, but as to the damages themselves, a plaintiff must show their damages. And so in our country, while reasonable royalty is the most common way, that's often because loss damages are difficult to calculate. So and I don't know if we will touch on this today, but one of the things that often happens in patent cases that there's a combination of damages which would be inclusive of both reasonable royalties and lost profits. As far as what goes into consideration, there are a litany of factors, and they are your materials, and I will not waste your time here today reading them back. but they are located on page 131 of your materials, and I would urge you to take a look at that. Thank you.
감사합니다. 다음은
Thank you
영국의
very
미드
much.
판사님께
And Judge Mead
부탁드리겠습니다.
from the UK.
Thank you very much. That's perfect timing because our electricity has just been restored. In the UK, the way that royalty damages work is as follows. If the patentee already monetizes the infringed patent by licensing it, then damages are assessed by reference to the licenses that have in fact been granted. If the patentee doesn't license the patent, then it can obtain compensatory damages for the actual loss it suffered if the loss was caused by the infringement and was foreseeable. And that's mostly relevant where the patentee and the infringer are competitors and the acts of infringement have prevented sales by the patentee. In relation to sales made by the infringer which haven't caused the patentee actual loss, the patentee is entitled to damages assessed on the basis of a notional reasonable royalty, as would have been agreed between a notional willing licensor and a notional willing licensee. And that's very similar to the position in the United States that Judge Bassoum has just explained. Where damages are calculated on the basis of a notional reasonable royalty, there are two ways of assessing it. One is by reference to comparable licenses between other parties or for similar inventions. And the other is by looking at the profits available to the licensee and splitting them in a fair and equitable way between the patentee and the infringer. So far as the burden of proof is concerned, in all matters relating to damages, the burden of proof is on the patentee. But there's an important qualification to that, which is that UK law recognises that a high degree of precision is not possible in the assessment of damages. And the fact that the patentee can't put a precise number on the damages doesn't mean that it's failed on the burden of proof. Our law recognises that damages must be assessed liberally, although not penally, and recognising that some roughness in the assessment is unavoidable.
네, 감사합니다.
Thank you very much.
이번에는 일본의 혼다 판사님께서
Judge
동영상
Honda from
보내주셨습니다.
Japan.
1번
He is
동영상
going
함께
to
보시겠습니다.
answer via video.
2の1についてから始めま
I'm
す。
going to look at
ロイヤリティを
2-1.
基準に
So
損害
when
賠
you
償
look
を
at
算
the
定する場合につ
damages
き、
based
我が国で
on
は
royalty,
特許法102条
we
3
follow
項
the
が
Patent Act
は
Article
規定しています。
102-3.
ロイヤリティ損害賠償につい
And
ての一般的な
royalty
計算方法は、
damages,
侵害品の
it
総売上
means
高に
that we
実
look
施
at
料率を
the
使用す
sales
ることになり
volume
ます。
of the infringing
実
product.
施料率を
And also
認定するために
for
考
the
慮されるべき要
effectors
素と
to
しては、
consider
当
to
該特許権
recognize
の
the
実施許諾
royalty,
例、
we look at
当
the
該事
actual
実分野にお
embodiment
ける実施料
example
率
or
例、
the
市場の
the
規模、
market size
当該
and
特
also
許
the
発明
value
の価
of
値、
the
代替技術の有
relevant
無、
the patent
侵害品
and
の販
also
売
whether
価
there's
格、
a
販売数
substitution
量、販売期
and
間、
also the
侵害品
retail
に当
price
該特許
and
発言が寄
also
与する場
other
合、
the
競合品の
apportionment
存
of
在、
the patent to
侵害
the
者と特許権
product
者の
and the
営業力な
existence
どが
of
考
a
えられま
competing
す。
product and also sales
特許法
power
102条
of
3項に
the
おける
infringer
実施
as
料
well.
相当額に影響を与える
So
べき
there
個
are
別事項の
some
実証
for
責
some
任について
special
は、
circumstances
特許
that
権者
can
に
have an
採用
impact
され
on
る
the
べき実
sales
施料相当額を実
the
証する責
product
任があることになりま
sales,
す。
then it falls
実
on
際
the
の訴訟において
patentee
は、
and in
特許権
actual
者において実施
litigation
料率を
the
高める要素
patentee
となる
can
個別事
increase
情
the
を述べ、他
royalty
方、
then they
侵害
need
者におい
to
て
make a
実施料
claim
率を
for
低める
such
要素となる
circumstances
個別事情
and
を述べるこ
also
とになります。
the infringer they need to make a claim for the cases that can lower the royalty. So it's great to hear that the electricity is back on in the UK. And Judge Jung from Korea. So let me give you my answer. So in the Korean as well, that is now considered as the the royalty can be utilized as damages, and the actual damages can be asked. The royalty can be asked as a damages, and the common prevailing license royalty can be claimed as damages. And there's no high court ruling about this specifically, but regarding the loss estimation, then for the first, we look at the technical value, and also we look at the license with the third party, and also we look at the past infringement cases, and also the remaining protection period of the patent, and also existence of substitute technology, and also the infringer's profit. So we look at all kinds of circumstances, and then so when we look at the royalty base, we multiply by the royalty rate, and when we look at the lower court decision, typically revenue looks at, and so revenue can be used as a basis, and the factor needs to be proven by the patentee. And also the patentee needs to prove each factor that led to the loss, and also to reduce the loss of the damages, then the defendants needs to prove that.
네, 감사합니다.
Thank you very much for your answer. And now
we will look at damages calculation based on the transferred quantity of the infringer. So, please comment on the calculation method and what factors are considered in such method of calculation, and who bears the burden of proof for each factor. And please keep your responses to 1 minute. We will start with Judge Klein from Germany. Judge, I believe you're on mute.
Really sorry, thanks. The sales quantity of infringing products may be a relevant factor when determining the damages based on those three methods that we use in Germany. So if damages are calculated based on royalty, sales quantity might be a factor to determine the license rate and or the total amount of damages that must be paid. If damages are calculated based on the infringer's profit, sales quantity might be a relevant factor to determine the total amount payable. The same goes for the lost profit. To the burden of proof, if the claimant relies on that factor, they might be bearing the burden of proof. Thank you.
네, 감사합니다. 저 다음은 미국의 비순 판사님께
Now, Judge
부탁드리겠습니다.
Bisun from the United States.
Yes, sales quantity would be relevant to both calculations of damages in the United States. So as to lost profits, the plaintiff would argue that the sales made by a defendant were sales that they could have made but for the infringement. So that would be the plaintiff's burden to demonstrate that. As to reasonable royalty, the sales quantity would be relevant to calculating the reasonable royalty and would probably serve as the base for any calculation of the reasonable royalty in the case. So, yes.
네, 감사합니다. 저 영국의 미드
Now,
판사.
Judge Mead from the UK.
네, 영국의 미드 판사님께 다시 부탁드리겠습니다.
Judge Mead from the UK.
Yes, thank you very much. The sales made by the infringer are relevant for essentially the same reasons as Judge Klein explained in the context of Germany. Although the burden of proof in a very theoretical sense lies with the patentee, obviously when it comes to establishing the amount the infringer has sold, that's primarily only in the knowledge of the infringer. And therefore, the UK has procedural methods to compel the infringer to disclose the amounts of its sales where necessary. Thank you.
Thank you. So in the Germany, US, and UK, they don't have legislative provisions, so they have based their answers on the cases. And now we will watch the recorded version of Judge Honda.
3-1です。特許権侵害の損害賠償を侵害者の販売数量に基づき算
When
定
it
するこ
comes
とにつき、
to
我が国では特
the
許法
damages caused by patent
102条1項
infringement, it
1
shall
号
be
が規定して
calculated
います。
based on the sales volume
特
of
許
the
法102
infringing
条1
product
項によっ
according to
て
Article
損害賠償額
102
を
of the
算定した
Patent
著名な
Act.
裁判例として
And
知財高裁
as a famous case,
2020
the
年2
beauty
月
instrument
28日の
case
判
is
決離眼期事件があ
famous
りま
ruled
す。
by the IP High
特
Court
許法102条1
on
項1号は
2020.
侵害者の
Pursuant
譲
to
渡した
Article
ものの数量に特許
102.1a of
権
the
者が
Patent
そ
Act,
の
the
侵害
amount
行為がな
obtained
け
by
れば
multiplying
販売する
profit
ことが
per
できたもの
unit
の
of the product
単
which
位
could
数
have
量
been
あたり
sold
の
by the
利益額を
patentee
乗
if
じた
it had
額
not
を
been for
特許権者
infringement
等
of the
の実施
patent
の
by the
能
quantity
力
of
の
the product
限度で損
the
害額と
infringer
し、
assigned
ただ
is
し
calculated as
譲渡
damages
数量の
within the
全部
limit
ま
of
たは一部に
patentee's
相当する
ability
数
to
量を
exercise
特
the
許権者
patented
等が販
invention,
売すること
provided
がで
that
きない
this
とする事
provision
情
was
を侵
designed
害者が
to
立証したと
recognize
きは
reduced sales
当該
volume
事
more
情に相当する
flexibly
数
in
量に応
case
じた
the
額を
infringer
控除
proves
す
the
るものと
circumstances where the
規定
patentee
して
is
い
not
ます。
allowed to sell
考
the
慮され
part
る要
or
素として
whole
は
of the
特許
assigned
権者等が
quantity.
侵害行為がなけ
The
れば販売
factors
す
to
る
be
ことができた
considered
ものである
are
こ
an
と、
item
特許権
the
者等
patentee
に
could have sold
実施の
if
能
the
力に応じた
infringement
数
had
量
not
を
occurred
超えない
and
部分であること、
patentee's ability
譲
to
渡数
practice the
量の全部
patented
または一部に相当する数
invention.
量を特許
The
権者等
corresponding
が
amount
販売す
has
る
to
こ
be
とができない
deducted
とす
when the
る事情があるとき
circumstances
は
that
当該事
do
情に
not
相当
allow
す
the
る数量
patentee to
を
sell the
控除
whole
す
or
ること
part
と
of the
されてい
assigned
ます。
quantity is
立
proved.
証責任については
The
特
burden
許
of
権者等が
proof
侵害行為がなけれ
for
ば販売することができたものであること
the
およ
sales
び特許
quantity
権
that
者
could
等
have
に
been sold
実
by
施
the
の能
patentee
力に
if
応
not
じ
for
た
the
数量を超え
infringement
ない部
lies
分である
with
こ
the
とについては特許権者
patentee.
側にあり、譲渡数量の全
And
部または一部
when
に
it
相当する
comes
数量
to the
を特許権
circumstances
者
that did
等
not
が
allow the
販売する
patentee
こと
to
ができな
sell
いと
even
す
if
る
it
事情
weren't
につ
for
い
the
ては
infringement
侵害
lies
者マ
with
ナー
the
とされています。
infringer. Thank you. And Judge Jong will explain the case in Korea. In the practice of Korea, the transferred amount is considered when calculating damages under Article 128, paragraph 2. It was recently amended, but before the amendment, the production capacity of the patentee set the limit of damages, and circumstances why it could not have been sold, even if not for the infringement, had to be reduced. This is still maintained after the amendment, but the biggest difference due to the amendment is that it is now stipulated in the statute that hybrid calculation is allowed, where we could add the royalty-based calculation. The burden of proof is basically with the patentee, but when it comes to the production capacity, it lies with the patentee. And when it comes to the circumstances where the patentee could not have sold, despite even if there weren't the infringement, it lies with the defendant. But under the amended law, currently it is still actively debated. Thank you. And we will move on to the damages calculation based on the infringer's profit. So under this calculation, please talk about the factors that should be considered and keep your responses to 1 minute. We will go to Judge Klein.
Thank you. So again, in Germany, the damages may be based on the infringer's profits. The patentee may only claim those profits which are based on the infringement. And I stress the base because courts need to establish a causal determination between certain profits and the infringement. If the infringer, for instance, provided special marketing efforts which led to part of the sales quantity, these efforts might decrease the infringer's profit, which are based on the infringement and which as such be needed to be compensated. Certain costs may diminish the profits, especially variable costs. Overhead expenses, for instance, only diminish the profits if they are directly related to the infringing product. So to the burden of proof, the patentee needs to prove that certain profits are based on the infringement. We will get to the apportionment in a second. And the infringer needs to prove that certain costs, especially overhead expenses, are directly related to the infringing product. Thank you.
네, 감사합니다. 좀
Thank you
미국의
very
비순
much. Moving on
판사님께
to Judge Bisun
부탁드리겠습니다.
from the States.
Well, my answer is very easy. We do not recognize that model of damages. And so in the United States, any sort of lost profit analysis is governed by the profits that would have been made by the plaintiff had the defendant not infringed its products. We do not look to the defendant's profits in order to assess damages. Thank you.
네, 감사합니다. 그러면 영국의
Thank
미드
you. Now,
판사님께
Judge Mead from the UK.
부탁드리겠습니다.
Thank you. Yes. In the UK, the patentee can usually choose between receiving damages or obtaining the infringer's profit. There's an absolute right to damages, but the remedy of an account of profits is in the discretion of the court, although it is nearly always allowed if the patentee chooses it. The account of profits is a restitutionary remedy which takes away the infringer's profits. And the profits to be paid are those that are actually made by reason of the infringement. The infringer cannot minimize what he or she has to pay by trying to pay only the incrementally greater profits that it's made compared with the profits it could have made by a non-infringing alternative. As with all other matters in the law of damages, as I've mentioned already, ultimately the burden of proof lies on the patentee, but again, in relation to an account of profits, many of the facts relevant to the assessment are only in the knowledge of the infringer, and we have procedural mechanisms in the UK, in particular by way of documentary disclosure, compulsory provision of documents, so that the infringer has to inform the patentee and the court of the factors going to the profits that it has made. Thank you.
네, 감사합니다.
Thank you. Now we will watch the recorded response of Judge Honda from Japan.
4-1です。我が国では特許法102条2項が
Article
侵害者は
102 of the
侵害
Patent
行為により
Act
受けた利益額
prescribes
を
that
特
the
許権
patentee
者
is
の
entitled
損
to the
害額と推
infringer's
定する
profits
規定を
obtained
設け
by
ています。
infringing the
この
patent
規定に
as
よると
damages.
特許権
The
者は自
patentee
己の
doesn't
単一
have
数量あたり
to
の利益額を
disclose
明ら
its
かにする
profit
こと
per
を回避
unit
することが
and
でき、
can
かつ相応の
anticipate
損
for
害賠償
calculation
額
of the
の算出
corresponding
が
amount of
見込み得ること
damages.
から、この
So
算定
this
方法が
method
特許権
is
侵害
the
訴訟に
most
おける損害
popular
賠
method of
償額の算
calculation
定方法
in
としては
Japan.
最も多く利用されています。同項では侵害者の利
The
益額が特
profits
許
of
権者の
the
損害と推定さ
infringer
れ
are
ます。その
presumed
上
to
で
be
この規定
damages
は
the
損
patentee
害
is
の発生の
entitled
推
to.
定規
However,
定で
if
あ
the
ることから、
circumstances that
その
lack
損害の一
causation
部または
supporting the
全部につ
damage
いて
done to the
特許権
patentee
者
are
が受けた損
recognized,
害と意見
the
関係
presumption
が
is
つける
partly
事情
rebutted
が
within
立
the
証されれば、
extent
その
of
限度で
the
損害の
infringer's
推定が
profits.
含めされることになります。侵害者の利益額に
As
ついては
for an
特許
account
権
of
者側
profit, the
に
patentee bears the
主張立証責任
burden
があります。
of
他
making a
方、
claim and providing
特別
evidence.
事情
In
について
terms
は
of
侵
the
害者側に主
causes
張立証責
for
任がありま
rebuttal,
す。
the infringer bears the burden thereof.
네, 감사합니다.
Thank you very much. And we will hear from Judge Jung about Korea. In Korea's practice, the profit of the infringer can be the basis for damages calculation under provision 4 of Article 128 of the Act. So it is presumed that the profit is damages, but if the infringer can establish that the actual profit that was lost on the part of the patentee is less than the profit of the infringer, then that amount can be rebutted. After the amendment, in fact, for the damages based on the infringer's profit, the hybrid calculation is not stipulated, but can be analogically applied to this case. And the burden of proof discussion is the same as the answer that I've provided before. Thank you. Thank you. Now we will move on to apportionment.
So regarding the royalty-based or the infringer's profit-based damages. So for these three scenarios that we talked about, now we want to talk about apportionment as well. So each judge from each country, we have 4 questions to you. And the first, so what are the consideration factors? And for the apportionment, do you have apportionment as a consideration factor? Second, how do you define apportionment? And third, what is the apportionment calculation method, and what are the consideration factors for apportionment? Fourth, in terms of calculating the apportionment, who bears the burden of proof for what factor? Please limit your answer to 2 minutes. We will start with Judge Klein from Germany.
So if royalty damages are claimed concerning the infringement by a complex product, where only parts or composites of the product are patented, the courts will have to determine if the complex product on the whole or a smaller unit or part is the adequate reference or allocation base or royalty base to calculate those damages. We don't have a clear definition of apportionment, but the courts will have to determine the adequate reference or allocation base to calculate the damages. The courts would determine, again, what reasonable parties would use as a royalty base. The courts will refer to common practice and also practicality. Courts should consider if the complex product is usually delivered on the whole, and if the complex's product value is increased by the patented part. The courts may again need to consider consulting an expert to determine common practice. The fact that the patent may only relate to a part of the complex product must also be considered when determining the adequate license rate. So we would look to the license base and the license rate. If the court cannot estimate an adequate royalty rate, again, it might need to consult an expert. So who bears the burden of proof? Generally, the party who relies on a certain fact. The infringed party may need to prove certain common license rate or allocation-based usages. If then the defendant wants to show to the court that those rates that the infringed parties refer to are wrong and there should be a lesser license rate used, then they might need to prove to the court exactly those rates that they stipulate. In concerning infringers' profits, the infringed party may only claim that portion of the profits which are based on the infringement, like I said. The right amount generally cannot be really calculated mathematically. It can only be estimated by the court. The courts need to take all relevant factors into account when considering those. Each party needs to prove those facts which are advantageous for them, all those factors that the court needs to take into consideration. Thank you.
네, 감사합니다.
Thank you very
미국의 비슨
much.
판사님께
Judge
미국에
Bison
대해서
from the
부탁드리겠습니다.
US.
Yes, the United States does recognize apportionment, and damages must be based on the value attributable to the patented technology as distinct from other unpatented features or as distinct from other non-infringing features of the product. Generally speaking, we are to use the smallest saleable unit that practices the patent and has a close relationship to the claimed invention. There is one exception to that, and I'll mention that briefly, but I did want to speak to the burdens of proof. As to that, that would be a defense that the defendant would raise, indicating that there is value in other parts of the device at issue, a multi-component device. So whether it be that they have additional patents in the device or there are non-patentable features that add value to the device, that would be the defendant's burden to demonstrate. An exception to the smallest saleable unit rule is something called the entire market value rule, which means that you may recover damages for an entire multi-component unit if you can demonstrate that the patented feature, the infringing feature, is the feature that drives the demand for that product. And so That would change the burdens of proof, and the plaintiff would be responsible for demonstrating that, no, your product is only valuable because of my invention that you put in it. And so that would be an exception to the smallest saleable unit rule in the United States. Thank you.
네,
Thank you very much.
네, 감사합니다. 영국의 미드 판사님께
Judge
영국에
Mead
대해서
from
질문
the
드리겠습니다.
UK.
부탁드립니다.
Yes, thank you. Where the patentee seeks to quantify the recovery that it makes by reference to actual damage that it has in fact suffered, then in English law, apportionment doesn't have much role to play, and the determination is one to do with causation and foreseeability. But where the patentee seeks damages based on a notional reasonable royalty, or especially on an account of profits, then an apportionment is necessary and significant. And it's worth saying just a little bit about how that works with an account of profits. Where the invention of the patent is the key ingredient in the infringing product, then in general, all the profits that the infringer has made after accounting for appropriate costs should be paid to the patentee. But where the infringing element is only part of the product, then there has to be an apportionment. And there's no hard and fast rule for the methodology of doing this. But in general, the court will look at ordinary accounting principles and to see how the infringer allocates profits itself. And in a number of cases, that has meant that the profits are apportioned in the same proportion as the infringer's actual costs. As with the other topics I've touched on already, ultimately the burden of proof lies on the patentee, but again, these are matters that tend to be in the knowledge of the infringer, and the infringer can be compelled to provide documents to the patentee and to the court so that the proper calculation can be made. Thank you.
네. 네, 감사합니다.
Thank you very
자,
much.
이번에는 일본에 대해서
Now I'd like to invite the
운용사 4번
Judge
영상을
Honda. We will look at the video number 4.
인테그레이션の2です。配分としては以下の事項が考えられます。
apportionment,
ロ
we
イヤ
can
リテ
look
ィ
at
損
the
害賠
following
償においては
factors. So,
侵
for
害者の
example,
営
we
業努
look
力、
at the
侵害者
infringer's
と特
sales
許権者と
effort
の営業
and
力の資格、
also the
当該特許発明の価
sales
値、
power
侵
of
害
the
品に当
infringer
該特許発
and
明
the
の寄与する
patent's
割合、
contribution to the
本
sales
件特許
value.
発明に関わらない部
And
分で侵
also,
害品
if
自体
we
の有している
look
優
at
れた特徴
whether
などが考えら
there
れ
is a
ます。
non-infringing
侵
part
害
of the
品の
product
販売
as
数
well.
量に基づく
And
損害
also,
賠償
when
にお
we
いては
look at the
特許権者の特許発明の
transferred
実施に
unit,
おい
then
て
we look at
特許
whether the
発明の特徴部分
patentee's
がその一部分
ability
に
to
過ぎない場
embody the
合には
practice.
限界利益
So
の
we
全
look
額
at the
が特許権者
patentee's
の逸利益とな
actual
ることの事実上の推定が一部含めされます。
capacity to
また、
produce, and
譲渡数
also
量の全部、
when we
ま
look
た
at
は
the
一部に相当する数
entirety
量
or
が
part of the
数量を
transferred
特許権者
unit,
等が販売することがで
then
きないと
we
する
look
事情
at
があるときは
the
当該事情に相
circumstances
当す
where
る
the
数
patentee
量分
couldn't
が
sell
控除されることになります。
but for the
この
infringement.
販売する
So
ことが
this
できない
part
とす
is
る事情と
deducted,
は、
and
侵害行為
also
と
this
特
kind
許
of
権者等の製
circumstances,
品の販売
it
減少との因
contributes
果
to
関係を
reduce the
阻害する事情
damages,
を言い、
and
例えば
also the
特許
causality
権者
needs
と
to be
侵害者
proven.
の
For example,
業
the
務対応や
patentee
価格等に
and
相違が
the
存在すること、
violators'
市場における競合品
sales
の損害、
powers difference,
侵
and
害者
also in
の
terms
営業
of
努
the
力、
circumstances,
侵
whether
害
there is
品
a
及び
competing
特許権
product
者
in the
の
market,
製品の
and
性質、
also
性
whether
能に
the performance,
相違
if
が
there's
存
a
在する
performance
ことな
difference
どが考え
between
られます。
the infringing
侵
product
害
and
者
the
の利益に基
patentee's
づく損害
products.
賠償におい
And
ては、
also
推定
for
含め事情
the
としては、1個の
infringer's
場合ほぼ
profit
同
is
様で
used
す。
as the
ま
basis,
た、
then the number
特許発
close
明が
one
侵害品
is
の部分のみに
applied
実施
as
されてい
well.
る場合において
And
も、
also
特許発明が実施されている部分
we
の
look
侵
at
害
the
品中
portion
におけ
of
る
the
位置づ
infringing
け、当該
products
特許発明の顧
and
客誘引
the
力等の
portion
事
of
情を
the,
総合考慮した結果、
patent in the
推定
infringing
不滅の
product.
事情として考慮されることもあります。 立
and those
証責任については
circumstances
ロ
are
イヤリティ損
considered.
害賠償においては
And
特許権者に
when
おいて
the
採用される
license
べ
is
き実施上
utilized
相
as
当額を立証
damages,
する必要があり
then
特許権者に立証責任があるということになります。
the
侵害品の
license
販売数量に
royalty
基づく
needs to
損
be
害賠
proven
償に
as a
おいて
reasonable
は
royalty.
特許発明の
And
特徴部分が
also, when
特許
a
実施人の
specific
一部に過
part
ぎな
of
い
the
場合の割合については
the
特許権
patent
者、それ以
is
外の区別
utilized
自由につい
for
ては侵
the
害者となりま
product,
す。
then
侵害者の利
the
益に基づく
infringer
損害
needs
賠
to
償において
prove
は推
that
定
there is
区別
also
事項として
non-infringing
侵害者
product
に
that
立証責任があり
contributed
ます。
to the value.
네,
Thank you
감사합니다.
very
자,
much.
이번에는
Now I'd
한국에
like to
대해서
invite
정의원 부장님
Judge
부탁드립니다.
Jung regarding the Korean situation.
실용신할 사건에서
So in the case of the utility rights case, there was a ruling by the High Court. So the royalty is used as apportionment, but there's no clear criteria for apportionment. In my personal view, if you look at the ruling, the meaning of the apportionment is that it's about how much it has impact on the overall performance and function of the overall product. So the percentage is assigned to the contribution of the patent, and when damages are calculated based on damages, then apportionment is not calculated first. The apportionment is used as one of the factors that's considered to calculate the royalty base, and also the profits, the infringer's profit is utilized, then apportionment is first calculated and then applied to the loss and damages. And for other factors, due to the time limit, please refer to my submitted question. And regarding who bears the burden of proof, in the design rights violation case in the High Court, the burden of proof for non-infringing part, it goes to the patentee. But in other cases, there are sometimes there's not enough evidence to prove the violators profit. So sometimes substantial loss is recognized. And regarding the burden of proof, in my personal view, about the apportionment factors, so we cannot have a one-size-fits-all rule to who bears the burden. We have to look at the allocation rule, and we have to also have to look at the causality relationship as well. We have to look at each factor's portion in the product. So that is my view. Thank you very much.
감사합니다.
Thank you.
그러면 이제 좀더
Thank you. Now let's take a look at some peculiar circumstances that we face in our judicial practice. As you can see in the questionnaire, in cases where the supply of components indispensable for the production of patented products is disrupted by market conditions, such circumstances could be considered. And second, there could be strong competitive products in the market that would correspond to 3-2 of the COM question in the reference book. And there could be circumstances on the infringer's side, 3-3. And there could be other IP rights contained in the infringing product, which corresponds to 3-5. So under such peculiar circumstances, I would like to ask questions to the different questions. There are three questions. So do such circumstances have an effect on the calculation of royalty damages? And if so, how specifically such circumstances can be considered in royalty damages calculation? And third, who is responsible for a burden of proof? Who bears the burden of proof for the existence or absence of such circumstances? We will start with Judge Klein from Germany.
Thank you. So regarding royalty damages, like I said, the courts would need to look at what reasonable parties would do. And so all those factors could be considered by reasonable parties who would try to get a contract, a license deal done. There's an ongoing debate in Germany if courts should look at the point at some point in time before the infringement happened or when the infringement ended. So if those factors were changed over time, there might actually be a difference if you concerning the time factor that you apply. In infringement cases, patent infringement cases, the Federal Court of Justice might actually look at the end of the infringement. So all those factors might be a basis for reasonable parties to consider during royalty negotiations, I would say. The court would need to establish which rate the reasonable parties would have used, maybe considering the consultation of an expert. Concerning the infringer's profits, those circumstances you mentioned may also be relevant. For instance, the actual sales quantity would need to be considered. If market conditions would have an effect on the sales, they might have an effect on the calculation, on the amount payable. A drop of sales because of competitive products could be relevant for the amount to be paid as infringer's profits. They could also be relevant for the determination for which proportion of the profits are actually based on the infringement. If the infringer provided special marketing efforts, again, the question is if those profits are based on the infringement and thus need to be compensated. Generally, the burden of proof is on the party that relies on certain positive facts. Thank you.
이번에는 미국의 비슨 판사님께 부탁드리겠습니다.
Judge Bisun from the US.
Okay, I thought it was. With respect to the supply of indispensable component, that would likely not be an issue that would be of concern in our analysis of damages, because ultimately the plaintiff has the burden of demonstrating how the infringing product affected its sales. And so to the extent that we're looking at lost profits, for example, the defendant would have the burden of demonstrating that the defendant, by virtue of using their patent in their product, made certain sales that should have been credited to the plaintiff in a perfect world. And so whether or not there was a supply chain disruption really just goes to the realities of the market and less to damages. With respect to competitive products in the market, that definitely would have an impact on damages, particularly in a lost profit analysis. If the realities of the marketplace demonstrated that competitors other than the plaintiff would have likely captured all or part of the sales made by the defendant. So that would have to be factored into any damages calculation, and the defendant would bear the burden of proof as to that issue. With respect to issues unrelated to the patented invention or perhaps design elements or other things that might be driving demand, that definitely is critical. As I discussed earlier, that would be a situation where we would have to apportion the amount of value of those unrelated items, unrelated to the infringing element items, so whether they be design elements, other patented elements of the infringing product, that would have to be apportioned if it was truly a driver of sales for the infringer's product. Thank you.
네, 감사합니다. 이번엔
Thank you.
영국의
Now,
미드
Judge Mead from the UK.
Yes, thank you very much. I think the UK position is quite similar to the US position in a number of respects. First of all, in relation to the effect of supply disruption in relation to indispensable components, if the patentee chooses to assess its claim by reference to its own actual lost profits, then it has to be able to prove that if the infringer hadn't made the sales in question, it would have been able to do that. And if there was a market disruption so that it wasn't in a position, in fact, to make the sales, if the infringer hadn't made them, then it wouldn't be able to claim actual lost profits, and it would be limited to a notional reasonable royalty. As far as competitive products go, I think there are two aspects to this. First of all, if it was established that there were third parties in the market with non-infringing competing products, then the court might conclude that the patentee wouldn't in fact have made the sales that the infringer did if the infringer hadn't, because they would instead have been made by those third parties. And that could reduce the damages or limit them to a notional reasonable royalty. But I would note that it's not open to an infringer to say that if it hadn't infringed, it would instead have been able to make the same sales in a non-infringing way. That's not an argument that's open to an infringer in UK law. I agree with Judge Bissoum that circumstances such as functional or price superiority, that sort of thing, would be regarded in UK law as an aspect of the exercise of apportionment. And we discussed that earlier. And I don't think there's anything additional to add in relation to the current question. Thank you very much.
네, 감사합니다. 이번에는 일본 혼다 판사님의
We will watch the
5번
response of Judge Honda from Japan.
インテグレーションの3の1などです。ロイヤリティ損害賠償についてまず見ますと、
When we look at damages calculation based on royalty, if there's disruption of indispensable component supply, or there are competitive products in the market, or the infringing products have superior qualities, or there are other IP rights in the infringing product, this will work as factors that will reduce the royalty damages in the calculation. The disruption of the indispensable component supply will have an impact on production and sales of the products and infringing products. And due to the gap in the price and function of the competitor product, when there is no sales of the infringing product, there could have been much demand that was shifted to the competitor product. And the function and price of the infringing product and other IP rights could attribute to sales growth of the infringing product. So these factors should be considered in the royalty calculation. And they are factors that will reduce the royalty damages, and infringer must prove or establish these factors. From the view of damages based on sales quantity, the disruption of the supply of the component and existence of competitive products and the superior qualities of infringing products and other IP rights in the infringing product, these are all factors that will work to reduce the royalty damages. The supply disruption for the essential component will affect the right holder's ability to exercise the patent rights, and the existence of competitive products, the superior qualities of infringing products, and other IP rights in the infringing product under Article 102 all fall under circumstances that hinders the patentee to sell the entire or part of its quantity of products. And the disruption of the supply of the critical component is what the patentee must prove, where the patentee must prove there was no disruption with the supply, and other circumstances attributable to rebuttal of the presumption of damages must be proven by the infringer. From the view of damages based on the infringer's profits, disruption of the supply chain, competitive products, and other IP rights will reduce the royalty damages as they partially rebut the presumption of damages, and in this case, the burden of proof will lie with the infringer, as it rebuts the presumption of damages partially. Thank you. I asked a bunch of very complex hypotheticals, but the panels gave us very enlightening responses. Thank you. Now, Judge Chung. When it comes to the disruption of the supply of essential component, we don't have a case that directly addresses such circumstance, but it can be deemed that the corresponding amounts have undermined the production capability of the patentee. And under Article 128, paragraph 2, this could work as a factor to reduce the amount the patentee could have sold under the sales quantity-based damages calculation. So it could partially rebut the presumption of damages because it is circumstances other than infringement that could have reduced the patentee's practice of the right. And if the infringer already received the element, then this would not be deemed as special circumstances, so would not affect the royalty base. But if such circumstances affect the economic value of the patented invention, then this could have an impact on the royalty rate or the profit per unit. And when it comes to the production capability, by principle, the burden of proof lies with the patentee. But when it comes to special peculiar circumstances where such supply chain disruption affects the amount that can be produced by the patentee, the burden of product should lie with the infringer. When there are competitive products in the market, this would hamper or undermine the sales ability of the patented invention, and this could fall under the scope of circumstances other than infringement that could lower the sales of the patentee. So the corresponding amount should be determined, and that should be reduced from the amount of damages. And the royalty rate and the profit per unit could be affected in a reasonable manner due to such circumstances. And if the quality of the infringing product is superior and if there are other IP rights, then along with the value of the patented invention, those other values must be included in the value of the infringing product. Therefore, whether this should be factors considered for apportionment, although we don't have directly related judicial precedent, in the lower courts, these have worked to lower the apportionment of the patented invention. So if the same perspective is applied, then it could be applied in the same manner for other cases of damages calculation. So those circumstances that reduce the damages, the defendant would bear the burden of proof.
감사합니다. 네, 이번에는 좀 더 구체적인 문제를
Now we will look at the more specific questions. So in practice, when we look at the apportionment, there are some factors to consider. So first, for example, when the patent is applied to only the part of the infringing product, so how is it considered? And that's the first question. And second, so if there is an impact, then the burden of proof of whether the existence, non-existence of this impact, who bears the burden of the proof. So actually, so this is the questions summarized on the slide. And the third question is at the bottom here, just additional question. So you gave us your answers in writing. So let me ask you the question once again. So if the patent is applied to only part of the product, and the other category is other circumstances. For example, the patent also includes other parts of the product. So including both these circumstances, do you look at this as factors for apportionment, or do you look at these two categories, distinct categories, so when you calculate the damages? So what is each country's situation? Can I ask you, Judge Klein from Germany first?
Thank you. So, like I said earlier, we do not have a clear definition of apportionment, but concerning royalty damages, we would probably consider those factors when considering the adequate royalty base and the adequate royalty rate. Concerning the infringer's profit, those factors would, well, obviously be considered to establish which share of the profit is based on the infringement. As to the general rules, as to the burden of proof, I would think that the general rules of burden of proof apply. So each party would need to prove those factors and those facts which are positive for them. Thank you.
네, 감사합니다. 이번에
Thank you very
미국의
much.
비슨
Now,
판사님께
Judge Bisson
부탁드립니다.
from the U.S.
Well, as I said earlier, we do recognize apportionment, and so the way this would play out in a practical way is that the defendant would be arguing that, in reality, various non-infringing components of its product, whatever it is, have some sort of value, and they would have to demonstrate that by a preponderance of the evidence in our court. They would probably do that through some of the methods that Mr. Bernstein mentioned yesterday. So, for example, survey information. So surveys about what drove somebody to purchase the product might be something that I would see in the context of a court case. And that would be presented by an expert witness demonstrating that there was value in other components aside from the infringing component of a multi-component device. And so that's generally how it would happen in the United States.
네. 네, 감사합니다.
Thank you very much.
이번에는 영국 상황을
Now,
미드 판사님께
Judge
부탁드립니다.
Mead from the UK.
Yes, thank you very much. If the infringing part is just an accessory to the real item of commerce, then the patentee can only get damages based on the accessory. But if the infringing part, despite being only part of the whole infringement, is integral to the infringing product as a whole, and the patentee can prove that the defendant's sale caused the loss of a sale by the patentee, then damages are awarded on the whole product, despite the fact that the patent only covers part of it. In relation to other facets of the defendant's activities, such as special characteristics, other IP rights, and so on and so forth, then in common with my colleagues who've spoken already, it's my view that that will be dealt with under the heading of apportionment that we have discussed already. Thank you very much.
네, 감사합니다.
Thank you very much. Now I want to ask Judge Honda from the UK, video 6.
インテグレーションの3の4です。
So integration 3-4. So for the damages, we look at some factors that can affect the royalty rate. For example, the transferred unit, and according to Patent Act, there's no specific definition for this. And this is not in itself recognized. For the infringer's profit, then the infringing product's market position is considered, and also the customer's attractiveness to the customers is also on other factors that can contribute to the sales of the infringing product is considered. So for a specific calculation methodology, if the reasonable royalty is the basis, then we look at how much value the patent added to the overall product value. And also for the infringer's profit, then we look at the presumption doctrine as well. So the patentee, they need to prove that their patent increased the contribution to the product, and also for the infringer's profit, then the infringer needs to prove that factor. Thank you very much. And now I'd like to ask Judge Jung for the Korean situation. The patent, if the patent is utilized only to the part, then that it needs to be recognized that it drove our entire demand, and also it also means that other parts made a contribution, so it can be a contribution to reduce the damages, and there is a similar lower court ruling, and the claim to lower the damages, it falls on the defendant to prove, but if the patent is applied only to certain part of the product, when that is clear, but if the plaintiff argues that their patent made a contribution to the entire product sales, and then claim that the entire sales volume of the product as the royalty base, then the plaintiff needs to prove that. So for other, so all these kind of factors, there's no clear Supreme Court ruling, but there are some lower court rulings for a few factors. Thank you very much.
감사합니다. 다음에는
Now we will move on to the common question of 4. As you can see on the slide,
지식재산권 침해가 인정됨에도 불구하고
are there any cases where a court did not acknowledge damages despite the infringement of IP right, especially with regards to calculation of royalty damages? Let's start with Judge Klein from Germany.
Thanks. So concerning royalty rates, in a trademark case of 2021, royalty damages, for instance, have been denied to a claimant who only gave out non-paid licenses. So the Federal Court of Justice reasoned that reasonable parties would not have determined a paying royalty if the rights holder usually did not claim paid royalties. I guess generally courts would consider these factors mentioned when determining the adequate royalty rate. If the patentee only uses the IP right once, he can still claim royalty damages. Concerning infringers' profits, courts have found that damages could not be calculated based on those profits if there was absolutely no connection between the development of sales quantities and the loss of profit on the infringer's part. But this is an exclusion which is pretty seldom. Thank you.
네, 감사합니다. 미국의 비슨 판사님께
Thank you, Judge Bisun from the
부탁드립니다.
States.
Well, it's a little bit of a complicated question, but generally speaking, the answer is no. If you are the victim of infringement, you are entitled to, at the very least, your reasonable royalty. However, I've said a few times that the plaintiff bears the burden of demonstrating their damages. So I suppose I could envision a situation where the plaintiff has not demonstrated to a jury, and in our system, these cases generally go to a jury for a decision as to damages. I don't usually calculate damages with the exception of enhanced damages, which we'll talk about later. But I could envision a situation where perhaps a plaintiff does not demonstrate its damages, but that would be the very rare occasion. So I think on balance, I would say no.
네, 감사합니다. 이번에는 영국의 미드 판사님께 영국의 상황을 질문해
Judge Mead from the UK.
Yes, thank you very much. In general, a patentee who's proved infringement has an absolute right to damages, and notional royalty damages can, in principle, always be assessed. So essentially, the answer is no. There is a very rare and I think only hypothetical exception, which is that it's recognized in some of the cases that damages can't be awarded if they would be contrary to public policy. That means that the patentee's behavior has to rise to the level of illegality. And in the theoretical case where the grant of a license was actually illegal, it might therefore almost uniquely be not possible to assess notional reasonable royalty damages. But this is a hypothetical case, and so far as I'm aware, it's never arisen in fact.
Thank you. Now let's watch the response of Judge Honda.
インテグレーションの4です。 ロイヤリティ損害賠償において
Well,
最高裁は
in the
1927
case of
年3月11日判決
1997,
商標権侵害訴訟において
in a
侵
high
害者
court
が商標権
decision,
許諾契約を受けていれば
if there was a licensee and there was an infringement of the trademark, then if the damages were not proven, then the patentee would not be entitled to the damages. And if through a licensing contract the patentee was to receive the royalty, the patentee would not have burden of proof. This would not work to limit the royalty damages for the patentee. And when we calculate damages based on the transferred quantity, then according or when there are other IP rights included, then there is a presumption of the damages. So theoretically, if the defendant can prove the rebuttal elements, then that would work to reduce the damages. But there are rarely cases where damages are not recognized at all. And when damages are not recognized, then there might be other factors such as the elements in practice. If there was a limit to the production capability, then these are reasons that could work to rebut partially the presumption of damages. Now, let's go to Judge Jung for the situation in Korea. When we recognize the damages, if the trademark was not used, then the damages could be rejected. This is the stance of the courts. So if the trademark was only registered and not used, then the damages might not be recognized, but this does not preclude damages in types other than royalties. Under such doctrine, this has been shown in cases, Supreme Court cases about the trademark, and the minimal damages that is guaranteed is what the right holder can earn by practicing the rights under the Act. But this cannot be interpreted as a defense that there were no damages at all. Under Article 128, when we calculate damages based on the sales quantity, there are reasons that could limit the amount of damages in the statute, such as circumstances that hamper the sales. Thank you. We will now move on to the next question about complex calculation. Royalty-based damages, or the sales quantity-based damages, or the infringer's profit-based damages. These are the three that are stipulated under Korean law, and other countries might have some applicable and others not. But when we calculate the lost profits, then the sales quantity of the infringer could be considered, or the profit of the infringer could be considered, which is common throughout the countries. So from the three methods of damages calculation, if two or more of the damages could be added, so the so-called complex calculation, whether this is applicable is the question. So is this hybrid or complex calculation recognized in your countries? And if so, how exactly does the calculation take place? What are the factors that should be considered in the calculation? And last but not least, who bears the burden of proof for each of the factors? Let's move to Judge Klein.
Thanks. So generally, in Germany, the infringed party may choose the method by which to calculate damages. If the claimant pursues more than one infringing act, and each act would be separable concerning time and concerning a local aspect, for instance, then the claimant could use several methods for each infringing act. The claimant is generally not allowed to use more than one calculation method concerning only one act of infringement. However, if the infringed party calculates damages based on royalties, they may additionally claim damages which go beyond those royalties if the royalty damages and the additional damages are based on different circumstances, but those would be pretty seldom circumstances. Damages which are not included in the calculation of damages based on these three methods, for instance, discredit damages, those would be claimed additionally. Thank you.
네, 다음은 미국의 비슨
Now,
판사님께
Judge Bisun
부탁드리겠습니다.
from the States.
As I mentioned earlier, there are only two methods of calculating damages in the United States: lost profits and reasonable royalty. With respect to those, I mentioned also that reasonable royalty is the most commonly used. That's typically because it's sometimes difficult for a plaintiff to demonstrate its full lost profits. The whole goal in the United States patent system is to make a plaintiff whole who has had a patent that has been infringed. And so the idea is to get the plaintiff back to the point if the defendant had not infringed on the product. And so if, for example, in calculating lost profits, a plaintiff is not made entirely whole. So that could happen in a situation, for example, if there are other competitors in the market and the defendant could demonstrate that some of those competitors in the market may have gotten some of the sales on the infringing product. That might have an impact on a plaintiff's ability to demonstrate lost profits. And so if a plaintiff is not made entirely whole based upon a lost profit calculation, the law does recognize that you may use reasonable royalty to get a plaintiff back to whole. And so there may be a situation where there is a combination of both of those things that make a plaintiff whole for the alleged infringement. A lot of times, however, the parties throw lost profits to the side and simply move for damages on a reasonable royalty because there are fewer barriers to determining the correct amount with respect to reasonable royalty than there would be to lost profits. And so those two could be combined to come up with a number that makes a plaintiff whole, but oftentimes it's simply a reasonable royalty calculation.
네, 감사합니다. 다음
Thank you.
영국의 미드 판사님께
Now,
부탁드립니다.
Judge Mead.
Thank you very much. Usually it turns out that the most favorable way of quantifying damages for a patentee is to try to prove actual lost profits caused by the infringer's sales. And our system allows a patentee to argue for any particular sale by the infringer that he, the patentee, would have made that sale and therefore is entitled to lost profit sale. But as a fallback, if he hadn't made that sale, then he would have been entitled to a notional reasonable royalty. And in that sense, it's possible to combine a claim for actual lost profits with a claim for notional reasonable royalty. It's definitely not possible for a patentee to claim damages and an account of profits for the same infringement. The remedies are inconsistent and you can only have one of them. In theory, it might be possible for a patentee to claim damages for some infringements and an account of profits for other discrete, separate infringements. But some first instance decisions have said that this will rarely be permitted and that the court, as a matter of its case management powers, won't allow it because it is excessively complex. Thank you very much.
네, 감사합니다. 이번은 일본의 답변.
Now, we will watch the response of Judge Honda.
원캉을 시청하시겠습니다.
5の1です。
In order to deal with the difficulty of proving lost profits, the Japanese Patent Act have the following provisions. Damages are the sum calculated by multiplying the patentee's profit per unit by the infringer's assigned quantity. The infringer's profits are assessed as damages. If the grounds for damages rebuttal or proven that the patentee did not suffer the equivalent amount of loss to such damages, the deduction of damages can be recognized. Concerning the said deduction, there are three academic theories about whether it is possible to combine a claim for damages based on royalty as defined in Article 102 of the Patent Act, one that advocates a hybrid calculation, another one that negates it, and the last one that determines the possibility of a hybrid calculation based on deduction factors. The trend of old precedents shows that the advocating theory prevailed in the past. However, the trend was reversed and many following cases adopted the negating theory. With the amendment of the Patent Act in May 2019, the lost profits caused by a reduction in the sales quantity and the lost profits caused by the loss of licensing opportunities were newly added to the damages section in the Article 102. How Article 102 of the Patent Act applies and what effect it will have on the calculation of damages under Article 102 that remains the same are gaining much attention. Just like Article 102, 1, 2, and 3 of the old Patent Act, as to the profit per unit, the infringer's assigned quantity, the infringer's profits, the infringer's total sales and royalty rates, the patentee bears the burden of proof, and as to the circumstances for rebuttal, the evidential burden rests on the infringer. Now we will hear from Judge Jung about Korea. As I have mentioned, under the amended Act Article 102, when damages are calculated based on the sales quantity, the hybrid calculation is stipulated in law. And when it comes to the infringer's profit-based calculation, it is not stipulated in law but can be analogously applied. If the damages amount goes beyond the production capability of the patentee, or there are circumstances other than infringement that hamper sales, then the damage is based on sales quantity. Here, it would not be deemed as the damages that should be paid, but royalty-based damages, it could be recognized for damages. I believe that whether we proceeded with a single method or we proceeded with hybrid calculation, this would not change the factors to be considered or the method of calculation. So the production capability of the patentee, circumstances that hamper sales, or reasons why licensing agreement was impossible. Such reasons can be applied in the same manner despite what is in the statute. The details about calculation method, factors, and burden of proof is pretty much the same as what I have explained in the previous questions with regards to damages calculation. Thank you. Yes, so we have learned about the practice on the hybrid calculation. Now we will move on to enhanced damages.
So regarding, there is a concept called the punitive damages. That's another name for enhanced damages. Some countries recognize that, some countries do not. So for more efficient discussion per question, even for a common question, so we will specify some countries that may answer the question. First, regarding the IP rights and anti-competitive actions. So punitive damages, is it recognized in your country or not? UK and US, Germany and Japan. And also if you can cite some cases, that will be great. We will start with Judge Mead from the UK.
Yes, thank you very much. There are some specific UK provisions which allow for enhanced damages. So, for example, under the Copyright Designs and Patents Act of 1988, additional damages in relation to copyright infringement can be awarded for what is called flagrant damage, flagrant infringement, excuse me, so heinous, especially bad damage, and especially infringements that are done in the calculation that the infringer will make more from it than they will have to pay to the patentee. So there are a few individual provisions like that, but more importantly, we have some regulations from 2006 in relation to IP enforcement generally, which were passed at a time when the UK was still part of the European Union, and which we have retained since we left it. And those are identified in the materials for the conference. And those have general provisions allowing for enhanced damages in intellectual property cases where the infringement was knowing, in other words, where the infringer was aware that the act that he or she was going to do constituted an infringement of an IP right. So the answer is we have some occasional specific provisions, and we have these more general regulations which we have retained since Brexit.
Thank you very much. Judge Klein from Germany.
Thank you. So in patent rights, generally, there are no enhanced damages. If the claimant asks for a royalty, damage, a royalty license, the individual situation of the case at hand might make it necessary to increase the royalty rate based on the fact that the infringer is not a normal licensee. But there is no general add-on. This is very important to our general system. In copyright cases, there is also usually no room for enhanced damages, but there are certain right holders who are awarded double the damages because they have to maintain certain expensive control systems to defend their rights. So this is a very special situation. Other than that, in trademark rights, unfair competition, and trade secrets, there is no room for enhanced damages. Thank you.
Thank you very much. Now, Judge Honda from Japan. Now we will look at video 9.
6-1-1です。
So we will look at the punitive damages in Japan is not determined by the law. Regarding this, there is a High Court, the Supreme Court ruling in 1997, Heisei 5. So it was also relevant to the California court rule. So the punitive damages in Korea, according to a tort action, then it is about to recover the original amount. So even though there are some punitive damages in overseas cases, but we do not strictly enforce that in Japan. Thank you very much. Now I will move on to the next question. So now we will look at the IP violations and whether there's a criminal penalty in your country. Judge Klein, can you go first?
Sure. Thanks. So we do have provisions on the criminal penalties in the Patent Act, Trademark Act, in the Copyright Act, in the Trade Secrets Act, and in the Unfair Competition Act. And I would ask you all to please refer to the written material for further specification. I've provided those provisions there. I would like to mention that all those provisions, to my knowledge, I'm not a prosecutor anymore, are used very seldomly. So it's all about the civil enforcement. Thank you.
Thank you very much, Judge Honda from Japan. So video 10. So W-1-2, so the criminal penalty provisions is under the Patent Act actually. So the people who are violating the patent rights or license rights, then is punishable by a prison sentence below 10 years or fine below 1,000 yen, and also according to the Patent Act, then you can be prison. You can go to prison for less than 5 years, or fined up to 500 million yen if you violate the patent right or the exclusive license right. And there are also similar provisions in the Trademark act as well.
감사합니다. 자, 다음 질문으로
Thank you very much.
들어가겠습니다.
And now let me move on to the next
형사처벌과
question.
징역죄
So regarding
모두
the
마련된
criminal
법률과
penalty and punitive
말씀드립니다.
damages, if we talk about
이중처벌이라는 문제가
the
있지
laws, there
않나요?
is an issue of double
그래서
punishment.
징역죄
So
처벌은 명확히
punitive
규정하지 않은 것이 또 대상액을
enhanced
징역 8년
damages, is it going to be recognized, and if recognized, how much enhanced? And do you also consider criminal penalty when you consider the enhanced amount? Judge Mead from UK first.
Well, the short answer to this is that there are not enough cases to be able to give an answer. In fact, it's very rare for there to be parallel criminal and civil cases in intellectual property disputes in the UK. We have lots of civil litigation. We also have criminal prosecutions in relation typically to the counterfeiting of branded goods and that sort of thing. But it's extremely rare for there to be both kinds of case in relation to the same infringement. So there's a lack of case law to allow a clear answer to this question, I'm afraid. Thank you very much.
네, 감사합니다.
Thank you very
이번에는
much.
한국의 김광남 판사님께
Now Judge
부탁드리겠습니다.
Kim from Korea.
예, 안녕하십니까.
Good
서울고등법원
morning. I'm Kim
김광남
Kwang-nam from the Seoul High
판사입니다.
Court. So in Korea, regarding the intentional IP infringement, there is the criminal offense recognized and enhanced damages as well. So we are basically the only country in the world that loves IP rights this much. And also, at least in Korea, we believe that we really love the IP a lot. However, because of this too much excessive love, we run the risk of double punishment. And to avoid that risk, according to the Patent Act, when calculating the enhanced management, we have to consider the penalty, the fine as a penalty. So the fine is utilized as a damages reducing factor. But the enhanced damage system is allowed to enhance the right holder's remedy. So just because a penalty is allowed, it cannot be used as a damage reducing factor. So basically the court needs to strike the right balance between the double punishment principle and also the remedy to the right holder and also the culpability issue as well. Thank you very
네,
much.
감사합니다.
Thank you very
네,
much.
자세하게
So it was a very detailed and humorous answer, so thank you very
다음
much.
질문 드리겠습니다.
And next question
이번에는 일반
is
손해배상
about
제도와
the
비교하여
compared to
징역배상
the
이전 기준의
general
특별한 요건에 대해서
damages, what are the conditions to be met to allow punitive damages? The question goes to the US and Korea. Do you have any specific case as well? So Judge Bisun from the US first.
Yeah, in the United States, we do recognize enhanced damages in the context of patent litigation if it can be demonstrated by the plaintiff that the infringement was willful. The chief case involving that is in your materials, and it's called the Reed case, and there are a variety of factors that the court will look at to determine whether or not willfulness, the willfulness standard was met. And I say the court, again, willfulness itself is typically a jury determination. In terms of the damages to be awarded, that is left to the judge to decide, and so it's a little bit of a hybrid. The Reed factors are in your materials. I can go through them. It's whether the infringer deliberately copied the idea or design of another, whether the infringer, when it knew of the other's patent protection, investigated the scope of the patent and formed a good faith belief that the patent was invalid or that it did not infringe. The infringer's behavior as a party to the litigation, the infringer's size and financial condition, the closeness of the case, the duration of the infringer's misconduct, any remedial action made by the infringer, the infringer's motivation for harm, and whether the infringer attempted to conceal its misconduct. Those are all factors, depending on whether or not they are demonstrated in the context of the case, that the jury would be instructed to consider. And then once that's done, if the jury decides that there was willful behavior on the part of the defendant, at that point it's up to the court to decide how much damages to assess based upon that willful conduct, and the court is allowed to triple the damages, or so it's up to triple. It doesn't have to triple them, but it could be as many as 3 times the amount of damages demonstrated in the case.
네,
Thank you
감사드립니다.
very
한국의
much.
김광남 판사님께
Judge
한국에
Kim
대해서
from
부탁드립니다.
Korea.
예, 특허법은
So under
특허권을
the
침해한
Patent
행위가
Act, if the
고의적인
infringement
것으로
is
인정되는
intentional,
경우에만
only
배상액을
that is
300까지
recognized,
지급할 수
then
있다고
you can
규정하고
triple
있습니다.
the damages up to
여기서
3
고의적인
times. So
것의
what
의미가
is the
무엇인지가
meaning of
문제되는데요.
intentional here?
이를
That will be
정부에
an
따라
issue.
견해가 나뉘기도
So
합니다.
there are diverse
즉,
opinions
민법상
about this.
불법 행위
Under the
책임의
civil
사회
law,
고의와
the
균일하게
tort
보이는 면도 있고
liability should be
그보다
utilized
강한
as a
행위에
concept to look at the
가까운
intentionality.
것으로 보는
Some people
견해도
need to
있고
look. Some
그보다
people
약한
say that
두
no,
가지를
it should be
포함해서도
like
보는
malicious
견해도
intent.
있습니다.
Some people say gross
법원의 상고는
negligence should be
고의성이라고
considered
되어
as intentional.
입법 과정의 사회
So
동의를
the legal
정의하여
language
각각
here
다른
is
의미로
intentional
해석할
in the
논의도 있고
Korean Act.
또 이런
So
생각도
how
있습니다.
strong are we going
어릴
to
적에
interpret this word
친구들과
intentional?
싸울
For
때
example, when we were children, when we were fighting
고의적으로
against each other,
말하면
we would accuse each
고의로
other. You were
그랬지라고
intentional.
한것과 약한
So
의미로
maybe
사용해서 먹기도
the intentional, the legal word
즉
here
여러 가지
has
해석이
a less
불분명한
strong
것으로
meaning than
나타납니다.
when we were using it as a
예,
children.
증액배상 제도가 도입된
Uh,
지는 얼마
the
되지 않아
punitive
이에 대해
damages introduced in
명시적이고
Korea
한해도
only
있습니다.
recently, so there's a no clear case set by the Supreme Court in Korea, but in the lower court rulings, it understood to be similar to the tort action under the civil law. Now again, the question goes to Korea. So if you look at the requirement for punitive damages, so it is more about kind of subjective element on the infringer's part. So how are we going to prove that? So in practice, when the patentee, for the patentee to demonstrate that the infringing party was intentional, or for the infringing party to demonstrate that they were not intentional, what are some factors and what are the cases in Korea? So Korea really loves IP, as I mentioned. Still, it is very difficult to prove the intentionality in Korea as well. Now I want to talk about some criminal cases where the intentionality was at issue. The infringing party knew about the patented invention and also made an improvement on that, and then even registered the utility model, and then even cited the patented issue as a prior art. But there were some differences in the elements of the embodiment as well, and also got the infringing party got patent lawyers counsel that this does not constitute infringement as well. In this case, the Supreme Court looked at all these factors and also considered that it is difficult to prove the doctrine of equivalence here, so the intentionality was denied. So basically, the intentionality needs to be determined based on various indirect factors. Thank you very much. And now next question goes to the US and Korea. And so whether punitive damage is recognized or not, and also expert opinion might be an important factor to determine that and to determine the punitive amount. So in practice, are there some requirements for the expert opinion in the US and Korea? For example, in-house counsel's opinion, does it constitute an expert opinion? Or in the expert opinion letter, what level of evidence is required? And what about the timing of writing that opinion letter? Judge Bison from the US, can you go first?
That may be one factor to consider when we are looking at whether something is willful or not. It used to be the case that if a party did not seek an opinion of counsel in the United States, that was a factor that could be considered against them in terms of determining willfulness. With the recent change in the law in the America Invents Act, that's no longer the case. So if you did not seek a letter of counsel with an opinion with respect to infringement, that is no longer considered a factor. So it's not a requirement. Although many entities do in fact seek an opinion of counsel as to whether or not they infringe, and so that is one of the factors that we could look at in determining willfulness, but it's not dispositive. There may be other behaviors on the part of the defendant that may lead us to conclude that it was a willful infringement. Some of it may go to how closely things were monitored, perhaps research and reverse engineering. There may be a variety of factors that we might look to. The letter from counsel is just one piece of the puzzle. I don't know that we really see much expert opinion in terms of determining the amount of punitive damages. That really is a court decision based upon a jury's finding that there's been willfulness based on all of the things that happened during the course of a trial. And so that's not really an area where we see willfulness. We see a lot of expert testimony.
네, 감사드립니다.
Thank you very
이번에는
much.
한국의 김광남
Now,
판사님께
Judge Kim
부탁드립니다.
again. So far, regarding the enhanced damages, the infringer's expert opinion letter submitted. No, it hasn't happened yet in Korea, but in Korea, punitive damages is now introduced formally. So going forward, an expert opinion submitted by the infringer is going to be an important factor. That's my opinion. But just because the infringer received legal counsel, it cannot constitute their effort to not to infringe. And also, if the issue is novelty and inventiveness, then for example, the expert opinion needs to contain specific analysis about the prior art and the relevant patent, and also if it is about the right attribution, then the letter needs to have a really detailed analysis about the comparison between the patent and the embodiment. And also, outside the counsel letter might be better, but if the in-house counsel's opinion has such a detailed analysis that I mentioned, it can be considered as a factor. Thank you very much. Now I'd like to ask this question to the UK judge. So we talked about various calculation methods, and some countries allow a complex calculation. And so no matter what kind of calculation method you use, can you allow punitive damages? If you do, then what about some factors? And are there any cases? So ratio, what about the ratio of the enhanced amount? Or do you look at, depending on what is the basis of the damages, does it factor into how you calculate the enhanced amount? And also, when complex calculation is utilized, then what about the transferred unit of the patentee? What about the lost profit of the patentee? So when the lost profit of the patentee is already recognized in calculating the calculation, still do you allow the enhanced damage? Judge Mead, can you go first?
Yes, thank you very much. The statutory provisions that I've referred to earlier on in answer to an earlier question don't specify whether they apply differently if complex calculation is used, and I don't see any reason in principle why they should apply differently. So I think the answer is that it won't matter across the board to enhance damages if complex calculation has been used, but there hasn't been case law that has tested this. I think one observation that's useful to make is that there could well be a difference between enhanced damages when the patentee or other right holder has chosen an account of profits, and situations where the right holder has opted for damages. Because where the right holder opts for damages, it's perfectly possible that those damages will not be as much as the profit that the infringer has made. And in that circumstance, it would seem logical that there's a greater place for enhanced damages to take away from the infringer the benefit that he otherwise might keep after he's paid the damages. So there's no definite answer, but I think those are the answers that should apply in principle. Thank you.
네, 감사드립니다.
Thank you very much.
이번에는
Now,
지금까지 논의했던
so far, we looked at the damages calculation, but including calculating damages, I'd like to ask the Chinese panelist to answer. So the Chinese panelist actually prepared a kind of a presentation, including all the topics that we talked about. So Judge Rowe, can you give us like comment within 5 minutes?
Yes. Good morning, ladies and gentlemen. Thanks for providing a separate time to speak the provisions, cases about the damage calculation. Please turn to slide to page 2. Article 71 of the China's patent law is a specific provision on the calculation of damages for patent infringement. Please turn to page 3. The damages for a patent infringement shall be determined according to the actual loss suffered by the right holder due to the infringement, or the benefits obtained by the infringer from the infringement, or if it is difficult to determine the loss suffered by the right holder or the benefits by the infringer, the damages shall be reasonably determined by the reference to the multiple of the royalty for this patent. In the case of an intentional patent infringement with serious circumstances, the damages may be determined as not less than 1 nor more than 5 times the amount determined in the aforesaid method. Please turn to page 4. The calculation method of actual loss is that it can be calculated by multiplying the total amount of sales reduction of the patentee's products due to infringement by the reasonable profit of each patent product. The calculation method of infringement income is the product of the total number of infringing products sold in the market multiplied by the reasonable profit of each infringing product. As for the calculation method of the multiple of a royalty, in practice, it should be noted that the payment method and the amount of royalty should adapt to the scope and the time of infringement, and the agreement on royalty between the two parties should be legal and effective. Of course, with the development of science, technology, and economy, more and more factors need to be considered. Please turn to next page. For enhanced damage, it is necessary to accurately apply the law to determine whether the defendant meets the conditions for enhanced damages. The slide shows the identification criteria for intentional and serious infringement of intellectual property rights. Page 6 and 7. As for statutory compensation, I have classified and listed the factors that need to be considered comprehensively as the page 7. And page 9. Next, I will share and page 9. Next page, please. Yes. Next. The next page. Yes. Thank you. Next, I will share cases on apportionment. Last year, one case was selected by the Supreme People's Court as the 50 typical intellectual property cases of Chinese courts in 2021 due to the precise determination of the amount of patent infringed damages. This case is a dispute over infringement of invention patent. Please turn to next page. Thank you. A Dutch company found that two companies, without its permission, sold and promised to sell several products, infringing its patent rights. So it appealed to the court to require the two companies stop the infringement and compensate for the losses. There are also some points in the above cases. 1. In this case, the compensation amount is calculated according to the calculation method of infringement income. As apportionment is involved, it also needs to be multiplied by the contribution rate of patents to profits. Second, China's judicial interpretation has also made relevant provisions about apportionment. That is, when the People's Court determines the profits gained by the infringer due to the infringement, the profits shall be limited to the profits gained by the infringer due to the infringement to the patent right, and those profits generated from other rights shall be reasonably excluded. In the above case, the contribution rate of the cutting device involved was calculated by comparing the transportation failure rate difference between the tire machine with the cutting device involved and the tire machine without the cutting device involved. Thank you very much for your attention. That's all.
네, 중국 류 판사님 감사드립니다.
Thank you,
지금까지 논의했던
Judge
지배권
Luo.
중에 손해배상의 산정에 대해서 중국의
We
법제와
were able to hear about China's legal system and cases about the issues that we have discussed. Now we will move on to the topic of efficient evidence collection and trial procedure in IP litigation. Now, this question goes to the US, Germany, and the UK. For efficient evidence collection, in your countries, are there any local rules for IP litigations? And if you do have local rules, please elaborate on the key points of such rules. Let's start with Judge Bisun.
On my court, and keep in mind there are 94 district courts in the United States, so we're not all the same, but my court happens to have local rules governing patent litigation. Trademark and copyright cases are treated like any other case. With respect to our local rules, they govern a lot of the activities in anticipation of trial, and so these would all be pre-trial issues. So, for example, our local rules would govern protective orders between the parties to safeguard proprietary and trade secret information. They would govern the timing of discovery as to issues of claim construction. They would govern also alternative dispute resolution. In my jurisdiction, we have mandatory alternative dispute resolution with respect to cases. Again, I'm speaking only for my jurisdiction because all of our courts are very different. Additionally, at that juncture, we also require the parties to set forth their assertion of claims, their claims of invalidity, and their infringement contentions so that they cannot change them along the way. And so we like to have them up front, say what those are, and those are the governing principles that will guide the litigation. And so they also must identify any advice of counsel at that juncture. This is so the parties have up front the information that they need in order to determine both issues involving claim construction, but also issues to try to settle the case at an early juncture. Thank you.
네, 감사합니다. 다음은 독일의 클라인 판사님께.
Moving on to Judge Klein from Germany.
Thank you. So the Regional Court of Munich 1 uses the so-called Munich procedure for patent infringement cases. And this procedure is basically based on the Code of Civil Procedure, of course. The procedure is aimed at streamlining argumentation and provide an efficient frame for the procedure. So it's mainly aimed at providing rules for the actual trial session. Parties are sent communications relating to the Munich procedure to explain everything they need to consider for preparing during trial and concerning their briefs. And so they are completely kept in the loop what they should do. So concerning the protection of trade secrets, I would like to focus on that aspect concerning our rules. Like I briefly mentioned yesterday, facts that are deemed trade secrets may be protected. And we ask the parties to, if they want to mention certain facts in a brief that are trade secrets, we ask them in our rules to please specify that directly in the heading of a certain brief and to highlight facts so that everybody knows that those facts are the ones that absolutely shall be kept secret. They are also asked to provide a blackened version, which is kept directly with the file, with the actual paper file, while we protect the file containing the brief containing the actual facts that need to be protected in a separate file that is totally kept secret. So it's a very important aspect of our work. We do get a lot of requests for trade protection and trade secrets protection. This is very important for many parties. Thanks.
Thank you. I will move on to the next question. In patent infringement cases, there are two steps, whether the patent was infringed or and adjudicating damages calculation. So I would like to know if the two steps are separated in your countries, and if the conclusion is different in the appellate court and the first trial court, then how do you proceed? Let's start with Judge Bisun.
With respect to bifurcating cases between damages and liability, that's done judge by judge. Yesterday, Attorney Bernstein did mention the difficulty in consistency among the various courts. Well, this complicates matters even more because that is a judge determination. So one judge can decide that they will bifurcate liability from damages. Another judge may decide not to. I generally do not bifurcate my cases. I've not had a situation where I have, but some of my colleagues have. With respect to how these cases go, that would only be an issue for the trial court because, again, the whole idea of bifurcating damages and liability is for the presentation to a jury. And so the argument would be that if you start presenting damages information to a jury, it might prejudice them into thinking that you are liable. So that really only happens in the context of the trial court level. That's not a factor that is considered at the appellate level.
네, 감사드립니다. 독일의 클라인
Thank you,
판사님,
Judge
독일에 대해서
Klein.
부탁드립니다.
Could you explain the situation in Germany?
Yeah, thanks. So in Germany, damages are usually not calculated in the infringement proceedings themselves. So I would like to call them proceeding 1. Concerning damages, the infringed parties usually only request the basic acknowledgement of the obligation of the defendant side to pay damages. So the court usually only establishes the basic obligation of the defendant to pay damages without addressing the individual amount. Individually, during proceedings 1, the infringed party would request information to enable the infringed party to calculate the damages. So the defendant will basically, if there is an infringement and the court educates concerning or according to the requests of the claimant, the defendant will be obligated to lay open his books, and there might be information contained that the plaintiff actually needs to calculate damages, for instance, based on the infringer's profit. The amount of damages the defendant will actually have to pay will be established in a second proceeding, the damages proceedings, and those are really seldom. I personally remember one case since 2018, since I started working in patent law, and I asked my colleagues who have been in patent law way longer, and one judge says, well, there was one case in 2012. So it is really seldom. And the case that I had in 2018 actually settled. So I did not decide on the damages of a patent infringement case. Concerning the question with the appellate court, usually the damages proceedings would take some time. So usually it would not happen that the regional court decides the damages amount before the appeal court has decided on the infringement. So I guess, like, well, first, there's no real risk of that happening because there are no real damage proceedings. And secondly, even if there were damage proceedings, probably the amount of time that has passed after the first decision of the court would be so large that there would be no opposing decisions. Thank you.
네, 감사합니다. 예, 다음은 2-1번 질문.
Thank you. Now we will move on to question 2-1 about the evidence collection procedures for patent infringement cases. So in Germany, could Judge Klein explain to us about the procedures in Germany?
Sure. So in Germany, we have a special section in the Patents Act relating to the possibility to inspect an item which allegedly infringes a patent. This provision would only usually relate to specific items that are, for instance, manufactured on a custom-made basis. So if you wanted to show the infringement by a mobile phone, for instance, the claimant would usually only buy a mobile phone. But if there are machines that might infringe the patent that are built only once or twice, and one of those is stationed in Germany, then you might actually need to look at this item to establish an infringement. The infringed party may get a preliminary injunction to enforce the rights stemming from the Section 140C, but actually these procedures are not very common. Based on that, they are quite complicated, but most important factor is, I guess, that the items that we usually see as an embodiment in infringement cases are those that can quite easily be bought on the open market. So you would not need to inspect a certain item. There are other procedural rules as well that really help the claimant in those circumstances. First, during infringement proceedings, Section 142 of the Code of Civil Procedure provides that the court may order the production of records or documents under certain circumstances. So we don't have a discovery like in the ES, as I understand it, if I understand correctly. But there are certain, for instance, the claimant asks for the production of certain documents and really explains why this special document is needed to prove some fact, then the court will examine this request. There are also procedural rules that may help the claimant relating to the burden of assertion and burden of proof, and those are really important in many cases. If the claimant shows to the court that a certain item must fall under the scope of the patent, for instance, because a certain technical effect is exactly the same in the embodiment than it is in the patent, but the claimant cannot show how this effect is achieved. So how does the embodiment actually work? If you think again about mobile phones, it's really hard to explain how some specific function in a mobile phone works, for instance. Then the burden to show how the embodiment works might shift to the defendant, because the defendant would usually know how the embodiment that they produce or sell works. So if the defendant claims that the item does not fall under the scope of the patent, the defendant will need to explain how exactly the item works, if not in the way that the patent actually provisions. And like I said, this is a very important factor, and in some cases we actually rely on this shifting of burden of assertion and proof. Thank you.
Thank you. Now, the next question is about the systems that orders the production of accounting documents. If the infringer does not produce the accounting documents or give false testimony about the documents, then what kind of disadvantages would they face? And if they do not produce the documents in the first trial, but they do in the appellate court, then does the disadvantages sustain in the appellate court? Could we first hear from Judge Honda in the video? Thank you. It's video number 12. If the infringer receives the order to produce documents but does not comply, then the facts that had to be proven by the documents can be presumed to be true. And if the party does not follow the order and makes specific claims about the specifications of the documents, then still the counterparties' claims could be deemed to be true. And if the documents were only produced in the appellate court, the appellate court is part of the first court. Therefore, the unfavorable disadvantages would hold. Therefore, if the documents were produced until the end of the arguments of the appellate court, then it is deemed to be submitted. And if the party intentionally or negligently produces delay in the documents, if there was such delay, then the court has the right to reject. And if it was only produced in the appellate court, then the effects would have to be considered in the decision. Moving on to Judge Mead from the UK.
Yes, thank you very much. The ultimate sanction for failure to provide
만약에 문서
accounting
제출을 하지
document
않는 이 회계
is for
자료를
the
제출하지 않는 것에
defendant's
대한 제재
defense to
조치는
be struck out.
그 항변의
In case the result will be that the patentee, the claimant, wins the case and prevails on its arguments. Theoretically, as well, eventually, a failure to produce documents could also be a contempt of court. But neither of these things are at all common. In fact, they're very rare, and nearly always parties comply with these orders eventually. In relation to the question about producing these documents in the appeal court, if a party had documents in its own possession during the first instance proceedings and was under an order to produce them but didn't, then in my view, it's incredibly unlikely that they would be allowed to submit them to the Court of Appeal at all. So that's the relevant sanction there. Thank you very much.
Thank you. Now, this is a question to the US and the UK. It is about the discovery system. Well, I know there's so much to cover about discovery, but when it comes to patent infringement cases, how much of the cost does the discovery contribute to? So how costly is it? And are there any additional members who assist with the procedure other than the judges? First, let's hear from Judge Bisun.
Discovery is probably the most expensive part of any litigation and the most contentious part of any litigation, even during trial, particularly in patent litigation when the parties are fighting over something that is exceptionally important to their businesses. The fighting about what should and should not be produced often takes up a lot of a judge's time. And so that process can last anywhere between 6 months and potentially a year sometimes. Parties exchange information, take deposition testimony, fight a lot, sometimes call on the judge to resolve disputes between them as to what is and isn't producible. And with respect to that, there are sometimes situations where, particularly where there are a lot of issues with discovery, or I like to call them problem lawyers who fight a lot, that some judges do assign special masters to those cases. Special masters are typically other lawyers who will agree to oversee the discovery process, particularly when it is taking up so much of a judge's time that it's difficult to do anything else, and that does happen. I have not assigned special masters in my cases. I think I do a good job at managing the disputes that arise, but there are a lot of my colleagues who do that, particularly when things become very problematic between the parties and they are not getting along or fighting over what should be produced and what shouldn't be produced.
네, 감사드립니다.
Thank you. Now, Judge Mead from the UK.
Yes, thank you very much. We have been gradually, and I hope successfully, reducing the amount of disclosure in patent cases over the years, and it's now a fairly modest part, although a very important part of patent procedure. We have limited disclosure so that the patentee can be informed about the characteristics of the defendant's product, which is normally achieved by requiring the defendant to provide a written description of the product or process in question. And we have very limited disclosure about validity. We don't have disclosure about validity as a whole. We have it on very specific issues, and in particular only if the defendant or the patentee was working in the field at the time of the patent using the cited prior art. So in general, now disclosure is quite a small part of a patent case in the UK. We have a goal of bringing patent cases to trial within 12 months from the time when the proceeding is initiated, which usually we are able to do. Sometimes we can't do that with bigger cases, but the disclosure phase of the case accounts for only a minority of that time, so maybe a few months. Patent cases are case managed by judges in the UK. There are very few exceptions to that. So the patent judges, deal with disclosure disputes when they happen. But in patent cases, we've got a fairly well established body of rules now, so there aren't so many disclosure contests as there used to be. Our system is an adversarial system, so we don't have a system where the judges have to read the disclosure themselves. The parties do that, and then they present to the judge at the trial whatever disclosure they think is relevant at that stage. Thank you very much.
Thank you. Now, we have a question for Germany and Japan. There was a newly system that was adopted in each of your countries. It covers a broad scope of issue, and since we already have a written response, so I think it'd be better to just skip these individual questions. Thank you for your understanding. And now we will move on to the topic of protection of trade secrets. It is the common question 3. Protection of the defendant's trade secrets is an important issue. So I'd like to ask a question to Germany and the UK about their relevant systems, starting with Judge Klein for Germany.
Thank you. So during patent infringement cases, the court can restrict access to certain documents so that parties can oblige to the burden of proof without fearing that trade secrets might be made public. This has been amended recently, like I touched upon earlier and also yesterday briefly. So at the Regional Munich Court, there are a lot of requests concerning handling certain documents as trade secrets and certain facts in those documents. And if both parties agree that certain documents contain trade secrets, the court will usually give out a corresponding order. If those trade secrets need to be addressed in court sessions, the court needs to examine if the public shall be excluded from the hearing. Usually our hearings are public, so it's kind of a heavy exclusion, but it's in some cases it's absolutely necessary to exclude the public. Also, if parties would not comply with the trade secrets protection decision of the court, they would well be liable to pay a quite heavy fine, up to 100,000 euros. So it's quite a heavy fine. In case of the procedures to collect evidence before in infringement cases, according to Section 140C of the Patent Act, which we touched upon briefly earlier, usually the court will obligate the applicant's attorneys to keep information they acquire by the evidence collection secret. So it's also a mandated, non-disclosure by the court. Thank you.
Thank you. Judge Mead from the UK.
Yes, thank you very much. We have also a system which is broadly similar, I think, to the German system. We call the methods that we use confidentiality clubs. So we have a limited list of parties and their advisors who are allowed to see the confidential material of the other side. The court has the power to sit in private without the public present, which it uses very carefully and very sparingly to the minimum extent possible to ensure open justice, and especially when there is going to be discussion of non-public confidential aspects of the defendant's product. And so we do that, and in addition, where necessary, we provide our judgments with a confidential section which only the people in the confidentiality club can see. But again, we do that very, very carefully and only when there is no other way to achieve it. Thank you very much.
Thank you. Now we will hear from Judge Luo in the recorded presentation about the proceedings and evidence collection procedure in China.
Okay, ladies and gentlemen, now I'd like to share about the burden of proof and the judicial procedure in light of the IPR-related civil trial practices. The Supreme People's Court developed several provisions on evidence in civil procedures involving intellectual property rights for the protection of trade secrets or other business information in litigation. The court shall require the relevant participant to sign a confidentiality agreement or make a commitment or order through a ruling or any other legal document to undertake confidentiality obligations. In China, the two steps of examining whether a patent right is infringed and of deciding damages are not independent. If a party appeals against the judgment of first instance, the court of second instance may uphold or reverse the original judgment according to the specific circumstances of the case. In the end, thank you very much for inviting me. Thank you. Especially, I would like to thank Judge Gu and Ara Kim. That's all. Thank you.
Then I would like to ask Germany if the damages can be ordered instead of the injunction. Please introduce the recent cases. So you can introduce the recent case of the Munich District Court.
Thank you. So, like I said earlier and yesterday, the Patent Act has been amended recently, last year, and there was an intense debate in the 2 years leading up to this amendment if courts should have to take proportionality into account more when and before deciding on ordering an injunction. And this discussion was, led especially concerning complex products, but not only related to complex products. But in the case of complex products, you do have the problem that a complex product might contain a lot of patents. Like, for instance, think about a car which might contain thousands of patents, and then a very small part which is protected by a certain patent. This patent might be infringed, and this might lead to an injunction. And actually, it could lead to the problem that the car manufacturer could not produce his car anymore, because even if it's a very, very small part, it might be quite vital to the car production. So this is the basic interest that was behind one of the reasons for amending the Patent Act, and one of the main focuses of the discussions before the amendment. Now, after the amendment, the right to an injunction, so it's a substantive claim actually in our patent law, the right to an injunction is excluded as far as, we will get back to that, in the specific constellation of the case at hand, taken into account the principles of good faith, the exertion of such right, so the injunction, would lead to a disproportionate hardship to the infringer or third party, both aspects, infringer or third party, and this would not be justified by the claimant's exclusive right, so it's patent. If the right to an injunction is excluded, the infringed party gets monetary compensation. The legislator amending the Patent Act underlined that the amendment only clarifies the legal situation. Proportionality is an issue which had to be considered by the courts even before the amendment. And for instance, I personally remember a case as a judge rapporteur where we had to take proportionality issues into account some years before the amendment. The Federal Court of Justice considered proportionality issues in their decision Wärmetauscher in 2016, a very famous decision in Germany, and this was obviously long before the amendment. And the legislator also made it clear that the injunction should remain the absolute rule, and the burden, while the exclusion is only the absolute, would only be considered in really exceptional cases, and the burden of proof is on the infringer. So which factors might be taken into account? On the patent holder's side, there might be taken into account the interest of getting an injunction to defend the patent holder's rights, obviously. On the other side, you could take economical effects of an injunction, the complexity of a product, and the willingness to accept a license of the infringer's part, and the fact that or if the infringed party performed an FTO, and interests of third parties into account. The fact that the claimant is an NPE could also be taken into account, but the fact that the claimant is an NPE would not in itself per se constitute a disproportionality usually. So in my opinion, the amendment has not changed the legal situation very much. The threshold to find for an exclusion still remains very high, like before the amendment, and the ordering of an injunction is the rule, not the exception. So the decisions that have been taken so far, for instance, from the Higher Regional Court of Düsseldorf and also from my court, absolutely stress this finding. In friend cases, we also have to consider the disproportionality defense. And I would like to mention a recent decision that we took in August, especially relating to the constellation where we have a friend defense and also this disproportionality defense by the defendant side. We do get disproportionality defenses a lot since the amendment, but like I said, there has not been a positive decision yet actually deciding on disproportionality. So in friend defenses, we would have the situation, like I talked about yesterday, that if the court decides that the infringer is not a willing licensee, so actually there could have been a license deal, but based on the actions of the infringer's side, this license deal was not furthered, so there is no actual license deal. And if the court finds that actually the infringer is an unwilling licensee, it would be doubtful if the court in this circumstance finds that still the injunction could be disproportionate. Because actually, if there was a license deal, the actions of the infringer would be legitimate because he would have a license deal. So on the one hand, if the friend defense is not successful based on the fact that the infringer is not a willing licensee, the court finds that this is due to the actions of the infringer's side. And so the court would usually not, concerning disproportionality, rule that at the same time there are circumstances which absolutely exceptionally speak for the defendant's side that there might not be an injunction. I would not say it's absolutely impossible to have both those defenses and on the one hand decide against the friend defense but find for the disproportionality defense, but probably the possibilities, the cases where those two defenses would have a different outcome would be very seldom, and we have not come upon one of those cases yet. One last point, I mentioned earlier this as far as. If the court decides that an injunction would be disproportionate, it would need to decide on the consequences. The law provides that the claim is only unsuccessful insofar as the injunction would be disproportionate, or as far as the injunction would be disproportionate. The court may not only take a black or white decision, so excluding the injunction or altering the injunction. What could happen, and in many cases probably would happen, is that the court would order a transitional period. So if you think about earlier the example that I gave, that there's a very smallish part in the car which is protected by a certain patent, maybe the car producer would need to have some time to find a workaround. And so there would be a transitional period during which maybe the patent could still be used. Actually, there would not be an injunction, or certain parts could still be used which are already manufactured at the car producer's side. And so the court would not totally exclude the right to an injunction, would only do so temporarily. The court would need to find the consequences that are actually adequate in a certain case. The court would need to weigh the interests of the parties again, and then decide if there's grounds for a total exclusion or only a part-timely exclusion. Like I said, well, the threshold in each and every case remains very high. Until now, the threshold to show disproportionality has not been met. But like I said, we do get a lot of those defenses and we consider them carefully. So there might be some new cases having a different outcome in the near future. With that, I thank you very much for your very kind attention. Thank you.
Thank you. We have heard very detailed responses, and we're sorry for the limited time. 120 minutes was not enough to cover these in-depth issues, but I would like to once again thank all of our panelists and all of our participants here on site. Thank you. That brings us to the close of session 4.
Thank you, everyone. This ends the 4th session. Let's give a big round of applause to the moderator and speaker of this session. 패널들께서는 사진 촬영하고 무대로 내려가시면 되겠습니다. 무대 위에서 사진 촬영하겠습니다. We will begin the mock arbitration session at 1:30 after a lunch break. 1시 30분까지 점심 식사 후 모의중재를 시작하겠습니다. 5분 후부터 식사를 제공합니다. 그 탁자 위에 소지품을 좀 치워주시면 감사하겠습니다. 그리고 잠시 퇴장하셨다가 5분 후에 들어오시면 좀 더 빠른 식사 제공이 가능할 것 같습니다. 그리고 대전역으로 가는 분들은 역으로 가는 차편이 마련되어 있으니 1시 20분에 탑승하여 주시면 감사하겠습니다.